major legal victory, the Federal High Court in Lagos has lifted a freezing order placed on the assets of General Hydrocarbons Limited, GHL, and its directors. The court found that First Bank had misled the court by suppressing key facts, including an existing order from Justice Ambrose Louis Alagua in a related case. Well, GHL's counsel successfully argued that the freezing order conflicted with Justice Lewis's earlier ruling. Now, the court ruled that First Bank had deliberately failed to disclose this, resulting in the wrongful freezing of GHL's accounts. Now, the court also agreed that First Bank had obtained the injunction through fraudulent misrepresentation, forcing the court to reverse its decision. The ruling clears the way for GHL directors who are now seeking $1 billion each in damages worldwide for defamation and wrongful freezing of their accounts. GHL has also filed a petition for unprofessional conduct with the Legal Practitioners Privileges Committee against First Bank's legal team. Well, lawyer and Arise News analyst Frank Tietie joins me now to unpack this recent legal battle between General Hydrocarbons Limited, GHL, and First Bank. Let's understand the legal grounds. Just elaborate for us on the legal basis upon which the court deemed that Mareva injunction inappropriate.
Oh, well, it can be easily, described and talked about in very cordial terms, but these are very serious issues. These are the issues we talk about all the time, and credit must be given to former Chief Justice of Nigeria, Justice Ariwola, who had complained helplessly that these are the forms of abuses of the court process that depict the judiciary as if it is as if it is engaged in a ridiculous exercise. In this case, particularly with General Hydrocarbons, is that we're witnessing a party that is outrightly misleading the court, lying to the court, in whether out of desperation or a clear attempt to subvert justice. And there are very strong and very dangerous, I would say, dimensions and implications to this, because we're dealing with a business in oil and gas industry where one day amount runs into hundreds of millions of dollars when it comes to the kind of contract.
Before we go into that, I just wanted you to stay on the implications of that non-disclosure. So the court found that First Bank failed to fully disclose existing order from a court of concurrent jurisdiction, leading to the setting aside of the injunction. How critical is full disclosure when it comes to ex parte applications? Oh,
extremely critical, because here we are, you meeting the judge alone without the other party who is affected being present. And even if he's present, he will neither be heard nor be allowed to speak. Now, the critical nature is that we're talking about the lawyers who owe very serious ethical, responsibilities to the court, to tell the court the truth at all times. And the presumption of the court is that everything in the affidavit is correct and is true, and that the court makes such a very sweeping and highly consequential order based on the representation of a party through his counsel. And now, and that's why I carefully use the word dangerous, because the implications are huge and very grave. And when a court does that, and it does that as a result of privilege, because there is a sense of urgency that is being presented to the court. In this case, just because you want to have it, so you alarm the court by telling the court lies or half-truth. And when you do that, it borders on fraudulent misrepresentation.
And what are some potential repercussions for a party that omits such information to the court?
It's not a question of omission here. It's about there's some intentionality, some deliberate, attempt to mislead the court, because this is an affidavit we're talking about. And we also have ministers in the temple of justice. I'm talking about the lawyers who are presenting such affidavits before the court, who are presumed to know the truth, but are now suppressing the truth. So the point here is suppression of truth, and nothing angers a court more than that. When a court is misled, the court will always be very civil and composed and may not betray any emotion with regards to that. But that is a huge threat to to judicial independence, and then it threatens justice dispensation entirely. It's a very serious matter, very, very serious matter for justice delivery, for truth, and in this case, business interests.
And let's look at some of the impact on GHL. The freezing order is now lifted. What sort of immediate, long-term effects might this have on GHL's operations?
Oh, no, it cannot actually be quantified. Only GHL can do that. But you see, I can only imagine it for a company, not only GHL, that has several contracts. The contracts of either supply contracts or contracts for service, in the sense that it is providing, it has entered the ask for service providers to work one day for an oil exploration company and runs into hundreds of millions of tens and hundreds of millions of dollars. And that can have very serious implications for equipment leasing, and for the things it has hired, and for the supply chain that is broken. I think we can leave that for General Hydrocarbons to determine. But you see, there is something more that is very risky about it. That is, when the idea, why would anybody contemplate, to attack and diminish the interest of a Nigerian company on a mere figment of imagination that with regards to facts that did not exist, and then go on a wild goose chase to intentionally destroy a business reputation, whereas such facts do not exist? Who would have such kind of intention? What sort of pettiness or jealousy would drive such persons to that? However, the implication is that the company will now begin to count its losses, that will drive it to seek some form of redress.
And which they are seeking redress already. Does this set any sort of significant precedents for future disputes, especially when it comes to disputes between financial institutions and corporate clients in Nigeria?
It may only serve as a precedent when there is some punitive action that is meted against the parties and those who actually orchestrated this. So I presume that there will be an investigation. But let me tell you, this happens all the time. The police does it to other persons, by just blocking accounts. You know the implication with regards to survival of a business or a person when you just freeze accounts based on an ex parte application. So the precedent we are expecting is that we're going to see a possibility that the National Judicial Council, the Legal Practitioners Privileges Committee, will come down very hard on this matter. We've seen the judge that has been very, very expressive. He didn't mince words about that. How on earth would you mislead a court to make that kind of order? Suppression of fact is even criminal. So we're thinking that the precedent will be complete if the investigation goes both criminal at the LPPC and then at the level of the National Judicial Council.
Good place to live it. Thank you so much, Frank Tietie, for joining me on Newsnight to unpack these legal issues.